Welcome, everybody. This is the Judges Chambers September 30th, 2025 call. And today, the topic that we are talking about has more to do specifically with the courtroom. It can be used for depositions as well, but this is going to be mostly for the courtroom, and I'll explain to you why. And what it is I want to teach you guys about cross-examination. I think cross-examination is incredibly important because if you guys go into any sort of hearing or trial, whether it be divorce or custody trial, or even just like a hearing along the way, an evidentiary hearing along the way where you're going to need to give testimony, you are going to be subject to cross-examination. And cross-examination is very important. When I was practicing full-time, both in family court and in criminal court, cross-examination was one of my absolute favorite things to do, because if you are good at it, and I was really good at it, you can really get the person tripped up. You can really get under their skin. You can really expose some things. The problem is you can also do that sometimes to innocent people, right? People who are credible, people who are telling the truth. So you guys got to be ready for that, because I don't want to get you too stressed about it or too nervous about it, but it is very important. Okay. That all being said, if you know what to look for and know how to handle it, you will do fine. Now, some of this stuff can also be used for deposition, right? Because when the other party's attorney in particular is taking your deposition, they're going to be a little bit combative, almost like a cross-examination situation, but it's not going to be quite as bad. So this is mainly for hearing or trial. However, if some of it you can adopt to depositions, then great. So first off, when we're talking about cross-examination, you guys got to know what it is. Obviously, some of you might know what it is. I know you've heard the term before. So what it is in your hearing or trial, when it's your turn to testify, your attorney will call you to the stand and you'll get sworn in, and your attorney will then go through what's called direct examination. So they will ask you the questions and I just see Daniel's name here. They'll say, like, could you please state your name for the record? Daniel will say, yeah, my name is such and such, and then go through all of the line of questioning. That's direct examination. The rules for direct examination is basically that you can't ask anything that's objectionable. You can't ask for an objectionable answer. You can't give an objectionable question either, and it has to be relevant to the case. Okay, but we're not going to get into that today. What happens then next is when your attorney is finished, your attorney will say, that's all, that's it, Your Honor, or no further questions, or whatever it may be. Then they'll sit down at counsel table if they're walking around, and then it'll be cross-examination time. And then what that is that the other lawyer now is able to ask you questions. And when they do this, no matter how nice of a smile they give you or how polite they're trying to be to you, you have to remember that this is adversarial. This is an adversarial situation. And it's okay if they are nice to you. I'm not telling you to like be a jerk to them or anything, but just don't let them calm you so much that you forget where you are and forget what you're doing, right? And then you just start to basically fall right into all of their traps. Okay, so the other attorney will come up. What you have to understand is, with cross-examination, if they are doing it correctly, every question, or most every question, will be a leading question, right? So for example, if this is a Whoop charger where it's like the heart rate monitor thing, if I would say, Daniel, what color is this Whoop charger? That's a non-leading question. Okay, that doesn't state the answer. A leading question would be, Daniel, this Whoop charger is black, isn't it? That's a leading question. And they'll do that the whole way through, right? Like, Daniel, you testified on direct blank. Isn't that correct? They're leading you because they're trying to push you and coax you into the answers that they want you to give, or they're trying to box you in to really have no choice but to give the answer that they want you to give. And it's very important to understand that, because what they're trying to do is they're trying to, like I said, lead you into traps and answer the questions the way that they want you to answer the questions, take things out of context. So what are their overall goals? I think if you guys understand their overall goals when they're giving your cross-examination, it's going to be easier for you to see where they're going with, yeah, Robert, aka legal gaslighting. Yeah, it can be for sure. Um, so their goal, they have a couple goals, right? A bunch of goals actually. One of the main goals that they're trying to do is to get under your skin, right? Especially if like there's been fighting amongst the two of you and they're trying to show that like you're the culprit, you're the cause of all the problems. They're trying to get under your skin to get you to snap. That's goal number one. Number two is they're trying to poke holes in your testimony of what you just said on direct examination. So all of that positive stuff that you just said, they're going to try to go through and like pick apart things and poke holes in it and either completely eliminate it from the game or at least mitigate it and weaken it. Okay, that's number two. Number three is they are trying to elicit negative testimony that was not covered on cross or direct examination, which maybe your attorney just didn't cover it, or maybe you're trying to cover something up, or whatever it may be. They're trying to elicit negative testimony, or it might be something that's exaggerated and you didn't talk about it because you didn't think it was a big deal. They're going to try to bring that up and make that into an issue. Okay. That was three. Number four is elicit positive evidence about their client. So maybe you didn't say something, maybe I don't know, maybe the other party is like the PTA president or something, and they're really involved with the school, and you just conveniently didn't talk about that. Which why would you, right? In that example. And they're going to try, maybe you talked about you went to an assembly at school, and then they're going to jump in and they're going to try to elicit the fact that the other side's the PTA and bring up positive evidence, right? And then finally, they're going to try to make you look like a liar. They're going to try to make you look like you're fabricating, like you're exaggerating, like you're embellishing, or like you're downright blatantly lying, right? It's all a game of credibility with cross-examination as well, because if they can destroy your credibility, if they do it effectively, and it's actually pretty tough to do in family court. But if they can do it, then what they do, like a lot of people think that like just because someone lies on the stand that they shouldn't like have their kids, or they shouldn't get alimony, or they shouldn't get child support or whatever. That's not the way it works. The way it works is that if you can make someone look like a liar on the stand, then at the end, through the briefs or oral arguments or whatever, you have the argument now to tell the judge, like, hey, judge, Daniel lied about this, this, and this. He's clearly lying about this, this, and this as well. And for that reason, we can't trust his testimony. So we can't accept it as true. So therefore, we have to accept my client's as true. And it's clear that my client has the credibility. And based on these factors that Your Honor considers, you should rule in our favor. That's a generic way to say, but that's basically what they're going to try to do when they're trying to prove you to be a liar. So how do they do this? They do a bunch of ways. First, they do it with pace of talking. That's like a really, really like important way, is they try to either really, really speed up the line of questioning, or like take really long breaks and get you to basically like fall asleep at the wheel. Or they'll like jump around, and their pace, they try to control the pace. Okay. The second way that they do that is through tone. I'm sure you've dealt with it with your ex a bunch of times, with like sarcastic tone, or smart aleck tone, like just a tone of like someone that is, you just want to like punch in the throat or something, right? Like you're just so irked by them, and they're the good ones can be very good at that. And then also they'll get argumentative at times with you. They'll just they'll ask questions, and quite honestly, argumentative questions are objectionable. So hopefully your attorney knows what they're doing. And if they ever really do get like truly argumentative, then your attorney will object, right? So those are the ways that the methods that they use to try to get what they want, right? They also take things out of context all of the time. So that's why it's really important. Like a couple of these lessons we talked about or in the course that I posted, we talk about evaluating and documenting your evidence and organizing it. That's why it's really important to make sure that your attorney has everything and make sure everything's organized. So if that ever happens and they take something out of context, then later in the hearing, you guys can clear up the context for the court. Okay. Now, what do you do when you're trying to combat all of these things? Well, there are a few really, really easy things that you guys can do to make sure to basically minimize any chance that they have it really like hitting a home run on cross examination. And the first one is you remember I mentioned that they like to control the pace. What you have to remember as a witness in the case, you control the pace. Okay. Do not feel obligated to match that attorney's pace. Do not feel obligated to quickly rush into the answers. Do not feel like that you have to like give the answer that they're looking for, right? I don't know if you've ever seen those things where like if you get somebody to spell top, spell top 20 times, T-O-P, 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 and then you ask them, what do they do at a green light? Invariably, people say stop, right? When obviously it's green. So it's that kind of like pace play that they're trying to, it's a psychological game is what it is, which is why I really liked it, because that's my background is psychology, to get you to answer how they want you to answer. So you just have to remember that you take one question at a freaking time and you answer at the dang pace that you want to answer. And don't worry about it. Like, do not worry about it. The judge is not, if the judge cannot like force you. Now, obviously, if you're like sitting there making yourself a sandwich and like eating and not answering, well, then sure, the judge is going to like tell you to answer. But if you're just like thinking or trying to give the right answer, don't worry about it. Okay. So that's number one. Number two, if they ask you anything that you do not know, you say you don't know. You do not guess on the stand ever, because the time that you guess, you're going to guess wrong and you're going to be wrong and you're going to look like you're lying. And then that's going to hinder your credibility for the rest of the case. So never guess. If you don't know, just tell them, hey, look, I honestly, I don't know. I don't know. I don't remember. Even if they have that smirk and the tone and everything else. And then also if you need, and you can use this to buy a little bit of time too, but if you don't understand the question, ask them to rephrase the question or say, hey, look, I really don't understand the question. Can you rephrase the question or can you repeat that? That's a good way to buy yourself some time. And it's a good way to make sure you're keeping the record clear so you know exactly what they're asking you. Because I'm telling you, like, those tiny little mistakes are like some of the things that can really hinder a case. And also too, like in preparation for this, like we talked about visualization, we talked about documentation and how to find what's important in your case and everything else. And I talked early on, I think maybe in the first call a few weeks ago, that we talked about how important confidence is. And this is exactly why I try to teach you guys all of this stuff that might seem like, oh, like I've had people say like, oh, well, my attorney should do that. Well, yeah, of course your attorney should do that. But the more confidence that you have in every single area of this case, the less likely it's going to be that you walk into that court so nervous that you have like subconscious defense mechanisms that take over. Maybe it'd be like a nervous laugh or, like a certain look you give or your body language, is in a way where those nerves can come off as lack of credibility. Like if a judge or whoever doesn't understand human psychology and doesn't understand anxiety and nerves, that can come off as lack of credibility. So that's why it's important to try to have all of this stuff down, so that when you walk in, you're comfortable and you're cool, calm, cool, and collected, right? And then, granted, it's gonna be tough. It's gonna be emotional. I'm not saying you're gonna feel like you're walking into an amusement park or anything, but like at least get it to the point where it's manageable. Okay. So I hope that helps. I think that's very important. And that's it. I'll get this posted in the group this week, and I'll put together a homework assignment for you too. And this will be up for you to watch whenever you want. So that's it. Thank you.